Martin is our speaker today on an international perspective on U.S. actions in and around Venezuela. Professor Martin teaches public international law, the law of armed conflict, constitutional law, and professional responsibility at Washburn University School of Law. His primary areas of scholarly interest in academic writing are international law, with an emphasis on the use of force and the law of armed conflict, and comparative constitutional law, with a focus on rights and war powers in Anglo-American and Japanese constitutional law. Professor Martin is also the co-director of the International and Comparative Law Center. Professor Martin grew up in St. Lucia, West Indies. He did his undergraduate work at the Royal Military College of Canada, graduating with a BA in History. He served 4 years as a naval officer in the Canadian Armed Forces. He also spent time as a naval attaché in the Canadian mission to the United Nations in New York City, where he worked on disarmament issues. Following his service, he went to Japan on a scholarship, where he spent close to 4 years studying Japanese and public law and conducting research on conflicts between Japan and the U.S. over Japan's international legal interests in Manchuria in the 1920s. Professor Martin graduated from Osaka University Graduate School of Law and Politics with a Master of Laws degree. He returned to Canada, studied at the University of Toronto Faculty of Law, earning a Juris Doctor. He became a member of the Law Society of Upper Canada, practicing civil litigation for 8 years in Toronto with 2 different firms, appearing before all levels of court and various administrative tribunals. During this time, he also taught courses at Osgoode Hall Law School in Toronto and at Osaka University Graduate School of Law and Politics. Professor Martin also completed a doctorate of juridical science at the University of Pennsylvania, Law School. His research examined the constitutional incorporation of international law principles on the use of force, looking at the Japanese Constitution as one example. He also developed theoretical arguments for greater constitutional limits on the use of force more generally in constitutional democracies. Welcome, Professor Martin.
Well, thank you very much. Thank you for that very generous introduction. I didn't realize my website profile was quite so long. I should have sent you a short bio, but thank you very much for that, and thank you for the invitation. It's really always very gratifying for a faculty member when a member, a former student, reaches out and invites him to something like this. It suggests that the student actually remembers you, which is wonderful. So I know I see Spencer may not be able to be here today, but he's the one who reached out to me, and I'm very grateful for that. So as Kai said, I was asked to speak about events in and around Venezuela. Since then, of course, there have been some related events regarding Greenland, so I'll speak a bit about that as well. I think they're both relevant and related to what has been going on in Venezuela. So just in terms of process, as I'm speaking, if there's something I've said that you think needs clarification or anyone has a question about what I'm speaking about, please don't hesitate to ask. But perhaps leave the broader questions, comments, objections to the Q&A. I'm going to try to limit my remarks to about half an hour so that we have lots of time for discussion and question and answer. So there's a few different issues which I'll address in turn. First is the lawfulness of the military strikes against and killing of alleged drug smugglers off of Venezuela and Colombia. Second are the seizure and confiscation of oil tankers and oil alleged to be carrying Venezuelan oil. Third is the military intervention in Venezuela to abduct President Maduro. And then finally, the recent threats to use force against Greenland. And there are some, of course, ancillary issues that some of you might be interested in, such as what the international law has to say about the immunity of President Maduro against prosecution in U.S. courts. We can talk about that perhaps in the Q&A. So to really unpack these issues, we have to understand particularly three different bodies of international law. And to the extent that some of you may not be familiar with those, let me just begin by talking a little bit about these three different bodies of law. The first is called the jus ad bellum. It's the Latin term for the international legal system that governs when countries can use force against other countries. These are the conditions or justifications for the use of force against other states. And so we'll talk a little bit about that. The second body of law is the law of armed conflict. It's related to jus ad bellum in that when a country uses force against another state, it triggers the operation of the law of armed conflict, also known as jus in bello, just to confuse things, or international humanitarian law, or IHL. The three terms relate to or describe the same body of law, which is a body of law that governs the conduct of armed forces in armed conflict. So when you hear about the Geneva Conventions and prisoners of war and who can be targeted and who can't be targeted, those are all concepts from jus in bello, law of armed conflict, IHL. And so we'll talk a little bit about whether and how IHL might apply, for example, to the killing of drug smugglers in boats off Venezuela. And then a final body of law, which as we'll talk about, is really quite applicable here, is international human rights law. Often confused with international humanitarian law because the name is familiar or similar, but quite distinct. Right? International human rights law is the body of law that governs our rights, our individual rights in our relationship with the state. They're quite analogous to constitutional rights. Constitutional rights govern your rights in relationship to the state within domestic law. International human rights law governs your rights, individual rights in your relationship with the state as a matter of international law. So when the United States enters into a treaty like the International Covenant on Civil and Political Rights, which articulates a body of rights, it is basically committing to other states and the international community that it will respect and enforce those rights for everyone within the territory and under the jurisdiction of the United States. And they overlap very much with constitutional rights. All right, so those are the three sort of bodies of law. I'll say maybe just very quickly that another area of law that seeps into many aspects of the issues that we're going to talk about is the concept of jurisdiction, right? So many of you are probably lawyers and have some sense of jurisdiction, but there's a basic principle in international law that countries, states can exercise their legal jurisdiction, whether it's the making of laws, the adjudication of laws, or the enforcing of laws. They can do all of those things. That's the exercise of their jurisdiction within the territory of the state, almost without restriction. But there is a presumption that they may not apply their laws or try to enforce their laws outside the territory of the state. Right? And these are the principles of jurisdiction, and we'll see how they crop up, particularly when we talk about the killing of alleged drug smugglers and the seizure of oil tankers. All right, so with that preface, let me turn to the military strikes on alleged drug smugglers in boats in the international waters off Venezuela and Colombia. I'm sure everybody is familiar with the facts. I won't go into those. There have been over 100 people now, I think, have been killed. So how do we assess the lawfulness of these strikes? Well, the government has not really produced a full-throated legal analysis. There is alleged to be an Office of Legal Counsel memo. The Office of Legal Counsel, of course, is an office within the Department of Justice that provides or develops memoranda that provide the justification, analysis and justification for the acts of government. And there's apparently an OLC memo that argues that these strikes are lawful. We don't know the exact contents of that memo. It's still classified. But the government has said that the strikes were acts of self-defense. and has referenced Article 51 of the United Nations Charter. So that implicates and triggers our thinking about jus ad bellum. To say that this is an act of self-defense is to basically say we are in the regime of jus ad bellum, that this is some kind of use of force in self-defense of the United States. So in order to assess that, we have to sort of look at it through the lens of jus ad bellum. And we very quickly determine, and by the way, most of what I'm going to say today, I would say, is completely uncontroversial. Right? If you go to the website Just Security, which is a very highly regarded website that covers national security and international law issues relating to American security, and is very much read by everybody on the Hill. You'll see that they have a collection of essays that have been accumulating over the last several months on these issues. And there is almost universal consensus among experts on international law regarding the things I'm about to explain. So I'm not really taking an outlier position or even a position that is refuted by anybody outside of the government. And the consensus view is that jus ad bellum just doesn't apply in this context because the force is being used against boats in international waters. Right? The jus ad bellum begins with a prohibition on the use of force against the territorial integrity and political independence of states. And so if you're blowing things up in the middle of the ocean, that doesn't implicate the jus ad bellum at all. And so self-defense just has no bearing. So the starting point is, well, jus ad bellum just doesn't apply. That isn't a justification for killing people on the ocean. But even if it did, for the sake of argument, if we thought that, well, is this a matter of self-defense? Self-defense, which is provided for in Article 51 of the UN Charter, requires that certain conditions be met before a country can use force in self-defense. And we'll come back to this when we talk about the military intervention to abduct Maduro. The conditions for the exercise of self-defense are that there has been an armed attack. There has been an armed attack or there is one imminent and irrevocably in motion. And the purpose of the use of force in self-defense has to be to prevent the continuation of that armed attack. It has to be necessary and proportionate. And so the three conditions are there has to be an armed attack and the response, the use of force, has to be both necessary and proportionate. None of those conditions are met here. There has never been an armed attack. The argument of the government is that somehow the shipment of fentanyl, which kills thousands of Americans every year, somehow constitutes an armed attack. That just simply doesn't fit within the scope of what constitutes an armed attack under international law. It doesn't even come close to meeting the threshold for what is an armed attack. An armed attack has been determined by the International Court of Justice to be the most grave form of a use of force. In other words, it has to be a kinetic use of force. And shipping drugs that may have second, third order effects of killing people or causing the deaths of people doesn't arise to the level of an armed attack. And of course, there are the factual problems with all of this because Venezuela is not responsible for shipping fentanyl in any event. I mean, we all know that to the extent that Venezuela is involved in the drug trade, it is cocaine, it's mostly going to Europe. So the idea that somehow killing of Venezuelan drug smugglers has anything to do with fentanyl is problematic. So that's the self-defense argument. The second argument advanced by the government is that, well, the United States is in an armed conflict, a non-international armed conflict with drug cartels. They initially listed two of them, Tren de la Agua, which is an existing drug cartel. They also mentioned a second, which more recently they have admitted is not actually a cartel at all. And have said that, well, we're in an armed conflict with these groups, and therefore the United States is authorized by law to use force against those individuals who are in effect combatants in that armed conflict. Well, again, this now implicates the body of law I mentioned earlier, which is the law of armed conflict or international humanitarian law. And the question of whether there is an armed conflict is a matter of law. It's not something you can simply just assert. You cannot just say, well, we're at war or in an armed conflict with the mafia. you have to look to law and certain principles of IHL to determine whether there is an armed conflict, and therefore whether the law of armed conflict actually is operating in that space. And this test or standard for when an armed conflict exists has been articulated by the appellate tribunal in the International Criminal Tribunal for the former Yugoslavia, the ICTY, in a case called Tadic, which said that in order for you to establish that there is an armed conflict, a non-international armed conflict, let me pause, back up for a second. There are two types of armed conflict. There's an international armed conflict, which is quite easy to define. It's when the armed forces of one country are engaged in hostilities with the armed forces of another. So if American forces start shooting soldiers on the other side of the border in Canada, there's an international armed conflict. Non-international armed conflict is a little trickier because this is an armed conflict between a state and organized armed groups, insurgents, so forth. And so we need a more defined standard for determining, well, does a non-international armed conflict exist? So for example, after 9/11, when the United States was killing members of Al-Qaeda and also of the Taliban, and the question arose, well, and also detaining members of Al-Qaeda in Guantanamo Bay, the question arose, well, is the United States in an armed conflict? Does the law of armed conflict actually apply in those circumstances? And the United States Supreme Court held in a case called Hamdan that the United States was in a non-international armed conflict with Al-Qaeda and the Taliban. And the US Supreme Court referenced the Tadic test. The Tadic test held that, or requires that you demonstrate that the state is engaged in hostilities of sufficient intensity and duration. They have to be protracted hostilities, like that is violence, with an organized armed group that is sufficiently organized and has a hierarchy and is actually capable of itself complying with the laws of armed conflict. So you have these two elements. There has to have been, you have to have an organized armed group that is sufficiently organized and hierarchical in nature, and that organized armed group is engaged in hostilities with the government of the state that are of sufficient intensity and sufficient duration. So applying the Tadic test to the situation here, we could say, well, is the United States in an armed conflict with Tren de la Agua, the Venezuelan drug cartel? Well, no. Tren de la Agua is not a organized armed group engaged in an armed conflict. It doesn't have sufficient organization, hierarchical structure. It's not engaged in hostilities. It's engaged in drug smuggling. It's a criminal business enterprise. It is not a political entity engaged in hostilities against the government, nor are there hostilities of any duration or intensity, right? Tren de la Agua is not engaged in hostilities at all with the United States, other than the fact that they're being killed on the high seas. To the extent that we know that these people who are being killed are actually members of the cartel, there's evidence that they are probably not, that they've just been hired by drug cartels as, you know, the flunkies that are actually transporting the drugs. So then the bottom line is the law of armed conflict does not apply because you don't have an armed conflict. And if there's no armed conflict, the law of armed conflict does not apply. And therefore, the authority, to the extent that one has authority, and there are some differences in theoretical positions on whether the law of armed conflict actually confers authority on states to use violent force, or whether there has to be some separate authority for that use of violence. But in any event, there's no question that the law of armed conflict does immunize members of armed forces, for example, from prosecution for killing, right? In war, in armed conflict, soldiers, combatants are entitled, authorized under law to do things that would otherwise be a crime, like kill and destroy and injure other people. And this is why the government, of course, is invoking the law of armed conflict, saying, well, our forces are entitled to kill these people under the law of armed conflict. These people are akin to combatants. But if there is no law of armed conflict, there's no such authority for killing, destroying, so forth, for the use of force. And before we get to the end of that, let's pause and say, well, what if it did? What if the law of armed conflict did apply? What if there was an armed conflict? Would these killings be permissible under the law of armed conflict? And again, the answer to that would be probably not, almost certainly not. Why? Because the people in the boats are not akin to combatants. Under the law of armed conflict, in international armed conflict, members of armed forces are entitled to kill the members of enemy armed forces simply based on their status, the fact that they are a combatant. Combatants, by virtue of their status, are targetable at all times. If they're watching a movie, they're sleeping, they're whatever they're doing, they can be killed because of their status as combatants. And certain members of armed forces are not combatants, like members of the medics, chaplains, right? People of that nature cannot be targeted. They are protected. And civilians are always protected, except for such time as they are taking direct part in hostilities, something that's called the DPH. So that's an international armed conflict. Civilians are protected. They are not to be targeted. It is a war crime to deliberately target civilians. Um, so let's move to a non-international armed conflict. Here it gets very confusing because the organized armed groups are not members of armed forces. They're not typically wearing uniforms. They're hard to determine who they are. And there are no such thing as combatants in a non-international armed conflict. So again, if we look back to, Afghanistan, when the United States was fighting Al-Qaeda and the Taliban, there were no combatants per se. And in a non-international armed conflict, everyone is considered to be a civilian, except that members of armed groups are typically targetable. They may be targeted and killed when they are taking direct part in hostilities. When are they taking direct part in hostilities? It's a complex question, which we don't need to go down that rabbit hole right now. The United States and other countries have taken the position that in certain circumstances, those members of armed groups can be said to be fulfilling a continuous combat function and therefore can be targeted on the basis of their status alone. It's a whole other debate. But to bring it back to the waters of Venezuela, there's no way that you could argue that drug smugglers are fulfilling the role of combatants or that they are civilians taking direct part in hostilities. Running drugs is not taking part in hostilities. So at the time that they are being killed, they cannot possibly be combatants or analogous to combatants in a non-international armed conflict. And therefore, even if the law of armed conflict applied, you would argue that the killing of these people is not permissible. Right? The targeting of these civilians, which is what they are, would be unlawful under the law of armed conflict. But again, just to rewind or zoom back out, the consensus view is it's not an armed conflict. The law of armed conflict doesn't apply, which is why, by the way, and we can come back to this in the Q&A, there was a huge brouhaha when it was determined that in the first strike, there were two survivors, and that half an hour after the first strike, the two survivors were then killed with a second strike, and everyone was saying, oh my God, this is a war crime. Well, it would be a war crime if the law of armed conflict applied, but the law of armed conflict does not apply. So it's not a war crime. It was simply murder to begin with, and it was murder with the second strike, right? How was it murder? Well, that brings us to the third legal regime, which is international human rights law. So if the jus ad bellum isn't applying and the law of armed conflict doesn't apply, then really we have to look to domestic criminal law and international human rights law, because that's the regime that's operating in the international sphere. International human rights law provides, among other things, the right to life, right? The most fundamental right. And while there is some debate regarding whether, for example, the International Covenant on Civil and Political Rights, which is the primary human rights treaty, applies extraterritorially. In other words, does it apply to people outside of the territory of the state? Most of the world thinks it does. The ICJ, the International Court of Justice, says it does. The International Human Rights Committee, which oversees the ICCPR, says it does. Most other states concede that it does. The United States says it doesn't. There's one of few countries in the world that says no. Article 2 of the ICCPR says that it must respect and enforce the rights of individuals articulated in the ICCPR who are within the territory and under the jurisdiction. And must mean and. In other words, you must be both within the territory and under the jurisdiction. The ICJ and, as I said, most other countries say that that and really means or. It's a disjunctive and that either in the territory or under the jurisdiction is sufficient. The American position, of course, narrows the scope of the ICCPR so that, and we can think of, as I get my students to think about it, you can think of many situations in which you would have an odd outcome if we really took and to mean and, so that in some ways people on reservations in the United States would not be under the protection of the ICCPR. Diplomats in the United States would not be under the protection of the ICCPR because they are not under the jurisdiction, even though they are within the territory. And people in Guantanamo Bay, Bagram Air Force Base, and so forth, places where the United States has tortured people, would be outside of the scope of the ICCPR, according to the American position, because they are perhaps under the jurisdiction, but not within the territory. In any event, regardless of whether the ICCPR as a treaty applies extraterritorially, the United States has conceded that customary international law, which is a body of law that's made up of unwritten principles and rules that are evidenced by widespread state practice and a consciousness of legal obligation, that customary international law rules around human rights, and particularly the right to life, do apply extraterritorially. And it would be an odd thing, it seems to me, and certainly courts like the European Court of Human Rights have said that when the agents of a state kill someone, that is an exercise of jurisdiction. That is bringing the person within the jurisdiction of the state. And it would be an odd thing to say that, well, in the exercise of that jurisdiction, somehow rights do not apply because rights cannot apply outside of the territory of the state. So the bottom line, given I need to speed up here, the bottom line is that international human rights applies, and so does, by the way, American domestic law. And I'm not going to really speak to the domestic law aspects of this, but experts on American domestic law have also said that, well, it's quite clear that American criminal law and other statutes would apply to this and would make this simply murder, right? That this is unlawful use of force. This is extrajudicial killing of people who have, in the past, been interdicted by the Coast Guard, arrested, brought to the United States, and prosecuted, which raises issues of jurisdiction. But regardless of that, I mean, that has been the American practice. The Navy has supported the Coast Guard in those operations, but only for purposes of support. The Coast Guard basically is the lead agency. They interdict, they arrest, they prosecute. And this shift to simply killing and choosing to kill rather than interdict, and it's been a deliberate choice, is arguably unlawful under international law. So turning to the second issue, the oil tankers, I'll be very brief because I do really want to leave a lot of time for discussion. There's a couple of different circumstances here. The first ship that was seized was called the Skipper. It was under a false flag. It was flying the Guyanese flag, but it wasn't registered in Guyana. That creates a certain circumstance. Because it's flying a false flag, it is essentially stateless. Right? The international law of the sea provides that ships must be registered and fly the flag of the country in which they're registered, and that the country of the flag has exclusive jurisdiction over the ship. If they are false flagged or not flying a flag, then they are stateless, and any country has a right to interdict and to inspect. Right? So the United States boarding of the Skipper was lawful. The confiscation of the ship and the oil, on the other hand, was not lawful, right? Like that was essentially an extraterritorial enforcement of American domestic law. Now, the Skipper was on the OFAC list, which is a list of designated entities for sanctions, because it had been identified as trying to evade American sanctions on Iran and Venezuela. And so there was domestic law authority. There was also a magistrate's warrant for the Skipper. So there was domestic law authority for the boarding and seizure of the Skipper. But again, the enforcement of that warrant and the confiscation of the oil would be an extraterritorial enforcement of American law, which is unlawful under international law. The second ship and subsequent ships were not stateless, right? So the Century, which was the second ship that was seized, was flying a Panamanian flag and was lawfully registered in Panama, and therefore Panama had exclusive authority and jurisdiction over the ship. And so even the boarding and seizure of the ship was unlawful, and certainly the confiscation of the oil again was an extraterritorial application of American law. And the United States justification is, well, the ship is part of a ghost fleet that is evading American sanctions, but those sanctions are American domestic law, and the attempt to enforce those sanctions in international waters by forcefully seizing and confiscating ships is arguably a violation of the prohibition on extraterritorial application of domestic law. So that's all I'll say for now about the ships. The military intervention, that is the use of force in Venezuela to abduct Maduro. This was characterized by the United States as a support for law enforcement operations. And they did this in part because they wanted to avoid having to report to Congress under the War Powers Act that they were engaged in hostilities and say, oh, no, no, this is just, we are just enforcing a warrant and arresting someone. And the military was there to support that law enforcement exercise. I'm not going to get into the War Powers Act and domestic law aspects of this, but as an international law matter, that is just irrelevant. This was a use of force against the territorial integrity and political independence of Venezuela. It was a use of force that was inconsistent with Article 2.4 of the UN Charter, right? Article 2.4 of the UN Charter lays down the fundamental prohibition on the use of force against other states. And the only way, and this, so again, just going back to the beginning of my talk, this brings us to the jus ad bellum, which is the legal regime that governs when states may use force. And there are two entrenched, accepted exceptions that allow for use of force. One is unilateral. States may use force under Article 51 of the UN Charter for individual or collective self-defense. That is in response to an armed attack. And secondly, they may use force when authorized by the UN Security Council under Article 42 of the UN Charter. Now, obviously, the UN Security Council did not authorize this operation. So the question is, can it satisfy the conditions for self-defense? As I mentioned earlier, self-defense requires that you show that there have been an armed attack, either against the United States or against some other state that has requested the assistance of the United States in collective self-defense. The United States has suggested that, oh, well, yes, this was a collective self-defense operation. We were defending Colombia and some other countries nearby. Again, first of all, the prior condition, the most important condition that must be met is there has to have been an armed attack. There was no armed attack, right? The alleged shipping of fentanyl or cocaine or whatever it might have been doesn't constitute an armed attack. It certainly wasn't an armed attack against Colombia. And so there's no armed attack. And if there's no armed attack, there is no self-defense. It's as simple as that. To the extent that you think that there might have been an armed attack, in order to satisfy the conditions for the exercise of collective self-defense, the countries that you are supposedly defending, so in this case, the United States arguably would be defending Colombia or other neighboring countries, would have to show that those countries have declared we have been the victim of an armed attack, and we are requesting explicitly for assistance. Those are two conditions that have to be met for collective self-defense. They obviously were not met in these circumstances. And again, you have to show that the use of force is both necessary to prevent the armed attack and was proportionate. And this intervention, which killed roughly 80 people, and seems to have been designed simply to abduct the president and had no other impact in terms of preventing ongoing drug smuggling or whatever, it simply makes no sense. So I think that it's pretty resoundingly clear. And again, everything I've said so far is reflective of a pretty broad consensus among all international law scholars and experts. Like, this is not a controversial issue. So for example, if I was talking to you about, the use of targeted killing of Al-Qaeda operatives in Yemen back during the global war on terror, there would be two sides to that debate. I would be taking one side, and I would have to acknowledge that there were scholars and experts who thought that really it was justifiable, and there would all kinds of arguments that would suggest that killing of Anwar al-Awlaki in Yemen was justified under the law of armed conflict. There's no such debate among international legal scholars about these issues. Like it's just pretty black and white. The final thing I said I would speak to before I open it up for questions is Greenland. I think it's pretty obvious that, again, if the United States were to use force against Greenland, it would be a violation of Article 2.4 of the UN Charter. It's the jus ad bellum regime. The same legal analysis would apply. You have to show that there's an armed attack. There's clearly no armed attack. The United States is simply just going to be using force against Greenland and its own NATO allies in order to conquer and occupy the territory of Greenland, right? It would be a use of force against the political independence and territorial integrity of Greenland as an autonomous territory of Denmark. It would have no justification whatsoever. It would be a profound violation of international law. And I should just note that Article 2.4 of the UN Charter prohibits the threat or use of force against the political independence or territorial integrity of any other state. So the mere threat of use of force is by itself a violation of this fundamental principle of the jus ad bellum regime. And it is quite, I think, arguable that the United States has already violated the principle by threatening the use of force against Greenland, even though at Davos, President Trump sort of walked back that threat and said, oh, he doesn't intend to use force. But prior to that, there had been all sorts of innuendo and insinuations that they would use force. And similarly, before the intervention in Venezuela, one could argue, and in fact, Michael Schmidt of the Naval War College did argue quite convincingly that the United States had threatened to use force against Venezuela, which is a violation of Article 2.4 of the Charter. So to round it out, what are the implications of all of this? I think that, they're profound. Right? The brazenness of these violations and the apparent contempt for international rule of law and just complete disregard for even trying to make any sort of sophisticated legal justification for these actions is really profoundly disturbing. It is why the Prime Minister of Canada at Davos earlier this week made the argument that we are seeing a complete rupture of the international legal order, right? And why international legal scholars are like just deeply depressed and feeling a great deal of anxiety because this really suggests possibly, the collapse of the international legal order and the international legal system that we have been living under since the end of World War II. So on that gloomy note, I'll stop and invite questions, comments, objections.
Thank you very much. Questions, and actually your presentation too, are being recorded, and we will, with your permission, post this as well. On such topics as this, we want you to be clear that you will be on record and will be searchable. So if you have second thoughts about that, we always honor our guests' views. But I'm quite convinced that you're very uncontroversial in this presentation. But let's see what Herb can scare up here in terms of a question, whether you can make it more controversial.
Now there is a charge. I want to say thank you very much for speaking to us on this matter. We are not just appreciative, we are honored.
Thank you.
A lot of the time, the research on the use and threat of force moves through different silos. And the those who study international politics, like myself, do not so often pay attention to what's going on in your silo, international law, even though in the real world they profoundly overlap. I would like to hear your perspective, and I have to admit I've written on this subject in the past, and you need not know it. How do you appraise for the world as a whole compliance with the often cited regimen emanating from and built on top of the United Nations Charter, which is a much more restrictive statement than the preceding from Versailles and before The Hague, and even more restrictive than that which existed before.
So can you just say the last part again?
How much does the behavior of states in the world that we see in overt military intervention or the threat of force comply with the strictures of the International Court of Justice system, the United Nations Charter even more, which specify certain requirements? How compliant are we as a whole, the world as a whole?
Well, it depends. Yeah, so it depends what you mean by we. We as the world as a whole. So famously, Louis Henkin, who is a international law scholar at NYU, famously said, most countries obey most of international law most of the time, and we tend to focus on the violations. And there are a number of theories, which I won't belabor everybody with, on why it is that countries comply with international law, because international law doesn't really have much in, a very sturdy enforcement mechanism, which is how it differs so much from domestic law. And yet, even then, when you think about domestic law, we obey domestic law. I mean, you guys all pay your taxes, even though, the risk of being caught for tax evasion is like very slim. Not really because you think you're going to get punished, but for a whole host of reasons. You think it's your duty, you think it's the right thing to do, you worry about what your neighbors would think if they thought you didn't, and for the same way, the same sorts of reasons, international law mobilizes compliance. In other words, it creates compliance pressure. States tend to obey and comply with international law most of the time. And of course, the jus ad bellum regime is one of those regimes where there's perhaps the most non-compliance, right? We see violations, and the violations are striking, right? They are in our face. When Russia invades Ukraine, it seems to us like, oh my God, there we go. There's no international law. But we don't think about it when we get on a plane and use our passport or send a letter overseas that's all made possible by international law, or go down to Costco and buy stuff from China. Like that's all made possible by compliance with international law. And even, there was just a study that came out just this week on the extent to which countries have complied with the orders and judgments of the International Court of Justice. And again, the number is very high, right? There are, again, these striking outliers. The United States refused for decades to comply with the International Court of Justice's decision in the Nicaragua versus United States decision. Ultimately, it did comply at the end of the day. It took decades, but it did, right? So the short answer to your question is, I think up until recently, quite a lot, right? And there's a wonderful book by two scholars at Yale called The Internationalists. Unfortunately, it's about 6 inches thick. So, but maybe over the summer, you can put it on your reading list. But it's a wonderful history of the way in which international law changed in the early 20th century to outlaw war. And it made the case really that, particularly since the 1928 Paris, the Pact of Paris, or the Kellogg-Briand Pact, states have actually, the incidence of states using force to acquire territory had become vanishingly thin. until the invasion of Ukraine by Russia, and which is why the Trump administration's flip-flop on Ukraine and the apparent endorsement of Russia's conquest and seizure of territory is so troubling. Right? And now the suggestion that we should seize Greenland. Like, I mean, this is really a radical departure from the way international law was up until really 2014 or 2022, depending on when you want to count the Russian invasion of Ukraine. So short answer is I think quite a lot. And I would just remind my very skeptical students who have studied international relations in undergrad and come to law school think that international law doesn't matter, that we don't think that just because the murder rate is high in Philadelphia that there is no criminal law in Philadelphia. We just think that the criminal law in Philadelphia is being violated quite often. It's like there are times when there are violations of international law and that they are quite notorious and quite in our face. But I would say that what we're seeing now is something different. We're seeing now a real rupture and a real threat to the possibility, a real possibility that the international legal regime and system, as we've understood it, is collapsing.
That very last statement is that you made there. I mean, much of what you went over was very familiar to me, but the way you're viewing that and that rupture that the Prime Minister of Canada, that was his word, and the way you've described that is quite a bit clearer now to me after your presentation. Also, on your comment or on your answer here, you talked about something that Ruth asked about. Maybe you have a few more words to say about it. She wondered, can there be consequences for violations of international law? You said it's not the same as domestic and criminal and civil law, the system. It's a different forum, but we're quite familiar with what consequences are in domestic law. What about consequences in international law?
Sure. And I've just posted a link to a podcast that I have, and I interviewed this professor from Columbia University earlier this month on this idea of the rupture and collapse. And it's quite theoretical, so it's maybe not for everyone, but I think it gets into the weeds of how we should understand this moment and what international law might look like after this rupture, and how we should think about law itself and how international law operates. It gets a little bit to your second question. What are the consequences? Again, it depends a little bit on what power we're talking about, right? And so, a middle power like Canada, Canada was taken to the Human Rights Committee by an Indigenous woman in the 1970s and accused of violating her right to equality under what was then known as the Indian Act in Canada. And the Human Rights Committee found that indeed Canada was violating her right to equality. And, Canada obviously is a country that cares very much about its reputation, thinks that it is a beacon of the rule of law and human rights, and so was embarrassed by this decision. It made her a senator. It changed the law. It did many things, right? North Korea probably doesn't care that much. And if you're the hegemon, United States, then you can afford to be less. You can disregard the decisions of tribunals to a greater extent. But even there, and this gets back to the theories about why is it that international law mobilizes compliance. For example, during the Bush administration, when the United States was engaged in torture, and just for those who may find that to be a harsh word and object, right? The Senate Subcommittee on Intelligence found that the CIA had engaged in torture, as did the European Court of Human Rights, and a number of other institutions and bodies have found that the United States was engaged in torture during the so-called global war on terror. And that had consequences, right? Even though the Bush administration took the position that they did not, first of all, they argued that they were not engaged in torture and that torture didn't apply and that they had their own definition of torture and the OLC memos that justified the so-called enhanced interrogation techniques, et cetera, et cetera. Nonetheless, when they were engaged in hostilities in Afghanistan, when there were meetings among allies and the members of the alliance or coalition of the willing, when the issue of detention came up, allies would leave the room. Officers of allied forces would say, thank you, we're adjourned. And they would leave the room. And this had an impact when, there was this sense that the United States was on this issue something of a pariah, right? And it could not get cooperation from its allies in the field because they felt that they could not be seen as participating and complicit in what they saw as unlawful conduct. And so you may think that that's a very soft consequence, but it had an impact and arguably changed the behavior of the United States. And I would say that international law operates in this way. It's not always there's not a consequence in the form of an order of a court that can be enforced by a sheriff, because there are no such sheriffs in international law, but there are judgments. I mean, another great example, which, by the way, President Trump dismissed rather contemptuously earlier this week, was the Chagos Islands decision of the International Court of Justice. Right, the Chagos Islands had been hived off from a group of islands belonging to Mauritius by the United Kingdom, and the people had been forcibly displaced, in part to lease an island called Diego Garcia to the United States and to create a military base. And they had been agitating for return to the islands and a recognition of their self-determination for years. It finally was sent to the ICJ by the UN General Assembly. And the ICJ handed down an advisory opinion, a non-binding opinion in a sense, holding that the United Kingdom was violating fundamental principles of international law and the self-determination of the Chagos Islanders. And the United Kingdom initially, as a wannabe superpower, a once upon a time superpower, sort of went, it's an advisory opinion. It doesn't, it's not binding. We don't have to pay attention to this. But last year, they returned the Chagos Islands. And so, even there, we see a fairly strong power over time succumbing to the pressure that what they were doing had been found to be unlawful by the highest court in the international system, and over time finally complying. I see many questions, so I'll pause there. And I'm happy to go over a few minutes if people have questions.
Thank you very much. Al or Mary Jo?
Yeah. Unlike so much that the Trump administration has done, the snatching and imprisonment of the Venezuelan president does not seem to be unprecedented. It seems like we've done the same thing in Honduras and Panama. Were those justified or were they different in degree or mode than what he's done in Venezuela?
So that gets into a lot of complex issues. So, the invasion of Panama is often looked at as sort of the analogy, and the precedent for what has been done in Venezuela. There are a number of differences. And first and foremost, first of all, I would say that the invasion of Panama was also unlawful, right, and could not be justified under the principles of jus ad bellum. At the time, there were some efforts by the U.S. government at the time to say, well, it was self-defense because a Marine had been killed in the Panama Canal Zone. And so there was this sort of self-defense argument. And then there was the protection of U.S. forces argument. So we were protecting nationals abroad, which is not an accepted, established justification for use of force. And there was sort of we were invited by the lawfully and legitimately elected president of Panama, which was really actually a pretext because the State Department wrote the letter, brought him into the Canal Zone, put the letter in front of him, predated, and had him sign it after the invasion. So the invasion of Panama itself was unlawful and therefore doesn't stand as a precedent. The prosecution of Noriega is somewhat different from the attempted prosecution of Maduro. Noriega was not really the head of state. I mean, he was a general. He sort of usurped the position of the legitimately elected president, but he wasn't even actually in the office of president. So he did not theoretically, technically hold the office of head of state of Panama at the time. And so he could not claim the kind of immunity that Maduro can claim, right? I mean, Maduro, I think the United States are going to have, well, whether the federal courts, what the federal courts do is going to be very interesting. But as a matter of international law, it's quite clear that Maduro has head of state immunity. And under the Pinochet case and other cases in international law, there's no question that as head of state, he enjoys immunity from prosecution in foreign courts, and that the United States should not be able to prosecute him as a matter of international law. Whether the federal courts find some exception for that is open to question.
Sure,
Other questions?
another thought.
First, thank you very much for your observations on the question I asked you before. It's especially comforting that we agree with each other and in print. Secondly, I need to confess a personal bias. A grandfather in my family was named David Jane Hill, who was the U.S. rep to the first Hague Conference when he was #2 in the State Department. And in 1908, he was in effect co-host of the second peace conference. He ministered to The Hague, widely credited by some, condemned by even more, for being the single strongest force on behalf of the creation of the Permanent Court of International Justice. But my question stems from an article which I recently read, which will give a different spirit. I hope you don't find it distasteful to address. And that has to do with the boat strikes, especially the one that killed the shipwrecked sailors. Can you comment upon that in the light of the famous case of Regina versus Dudley and Stevens? I think that's 1884, and the tradition that flows from that.
So, yeah, I'm not sure how Dudley and Stevenson applies here. So Dudley and Stevenson, for those who haven't heard of it, and if anyone's seen the Life of Pi, the movie, or read the book, the Life of Pi was directly inspired by Dudley versus Stevenson. Dudley versus Stevenson is a case that certainly law students in the Commonwealth, I'm not so sure in the United States, but in the Commonwealth all study, which involves a shipwreck in which there are 4 survivors in a lifeboat. And, on the 5th or so day, they start to realize that they're going to starve to death. And there is discussion of who should serve as a meal. And there's a drawing of straws, and ultimately they end up killing the cabin boy, who has already sort of incapacitated himself by drinking seawater. In any event, make a long story short, they eat the cabin boy. And, in sort of the details of wonderful 18th century court cases, the captain noted in his log that not long after breakfast, they sighted a ship. Breakfast, of course, having been the cabin boy. In any event, the case stands with they were prosecuted, and they tried to argue the principle of necessity and said that it was necessary for them to do what they did, and that they were justified by the principle of necessity, and the court rejects that principle. I have seen, I in passing saw a reference to the article I think you're referring to. Like, I saw that someone had raised Dudley versus Stevenson as somehow being relevant to the killing of the 2 survivors. I fail to see what the analogy is. Like, I don't understand how the government could possibly be raising Dudley versus Stevenson as somehow relevant to the killing of the two survivors.
The opposite. The question was raised in the article because the issue that was raised about justification, the context of the U.S. government justification, that it was necessary for the preservation of life and welfare in the United States.
Oh,
And but it gets to the thorny issue of the central issue in all those cases.
so yeah, that makes no sense to me. The principle of necessity. So in the Dudley versus Stevenson, and there are times in criminal law where there is this sort of so-called defense of necessity, although it doesn't. The House of Lords and or the Court of Appeal in England at the time found that it didn't justify homicide. But as a matter of international law, there is a principle of necessity. There is a doctrine of necessity that allows for certain actions for states. So to give an example, if a oil tanker is foundering, just outside of American territorial waters, and the question is, can the United States like destroy this oil tanker, destroy this property in order to prevent an ecological disaster, right? Because if the oil tanker drifts into American waters and breaks up and it will create an oil spill of catastrophic consequences, can the United States destroy that oil tanker? The doctrine of necessity, which has certain elements, which I won't bore you with, that have to be satisfied in order to invoke it, exists. And the answer to the question is often yes. If the United States can show that there's an urgent need, that a considerable state interest is at stake, that it can do something like destroy an oil tanker. But it's a fundamental principle of international law that you cannot invoke necessity as a justification for the use of force. It's just black letter law, right? I mean, the use of force is permissible on the basis of self-defense or Security Council authorization. There is no invocation of the doctrine of necessity for purposes of use of force. So I would just I would say that to dismiss the idea that Dudley versus Stevenson can justify the killing of or any of the uses of force here.
The article, by the way, appears in the latest issue of the Harvard Gazette. If you
Is
want,
that right? I will look it up.
Oh my God.
And
A
again,
great legal.
even if we were to take, so this isn't the use of force against the state, it's just the killing of individuals and whether necessity can authorize that. It's quite obvious that this is not necessary because the Coast Guard used to interdict and arrest and prosecute. And the Secretary of Defense is on record as saying that they simply made a decision not to do so, right? And that to use lethal force in these cases. So it's hard to argue that something is necessary when you have simply made a decision, a choice not to interdict and to arrest, but rather to kill.
agree.
I think I have a question for you that has a good segue from what you just said. There's so many things I'd like to ask you about and talk to you about, but I'll go on this one because I think it really hits. We have these former defense and security people who have given this PSA reminding soldiers that they don't have to follow any unlawful orders. And now we have the Department of Justice pursuing them for something like treason or insubordination. I suppose when they talk about, you're sitting in Washburn in Kansas, and I think the field command officers from around the world collect in Leavenworth. So it's actually Kansas is pretty much a hot spot on what military people lawfully can and should do. Are they only talking about domestic law when they say something that is lawful, or does anyone in JAG or the military have any concerns with international law at all?
Well, I haven't spoken to any of the JAGs who are directly implicated in this directly, but I have no doubt that JAGs are thinking about international law a great deal. I mean, they have to consider international humanitarian law. And it is a principle of international humanitarian law that under the Geneva Conventions that you have an obligation to not obey a manifestly unlawful order. I mean, that is, I mean, simply the codification of what is called the Nuremberg Principle, right? The defendants at Nuremberg argued that they were just following orders, and that defense was rejected at Nuremberg and has been codified in the Geneva Conventions and other instruments as simply it is not a defense that to say that one is following orders and that you have an obligation to not follow what are manifestly unlawful orders. Now, the question of were these orders manifestly unlawful? I mean, that's another, that's a complex area that we don't necessarily want to go down that rabbit hole right now. But, to say that there's an obligation to disobey manifestly unlawful orders is just simply to state black letter law and international law.
Okay. My sister is a lawyer, and when my son wanted to go to law school, he said he wanted to study international law, and she said it's an interesting idea, but it doesn't exist. Now, I think, she had her ideas that we had in civil and criminal law domestically, enforcement mechanisms that made law seem like a reasonable system. Now, I think she's changed her mind recently that it also may not exist there either, but in that same sense. So philosophically, you're saying that soft power of the United States as the hegemon in the world today, or one of them anyway, the major one, militarily, soft power is the major aspect that suffers. When we had the free world afraid of communism, we had some kind of argument that we could do whatever we wanted here and there for that purpose. The Marxist radicals said, but you're only doing that for your own, imperialistic means. Now, when we do those things against international law, for whose purpose or for what reason are we doing it? Sometimes they say anti-communism, but that really stretches it a lot and doesn't make sense anymore. It's used politically, but you're making me think that my radical Marxist friends were right all the time.
Well, so I guess I would distinguish a couple of things that you said. I think, first of all, I wouldn't classify it as soft power. I think that, as I said, international law operates differently in many respects from domestic law. And so it mobilizes compliance, it influences behavior in different ways, but I wouldn't quite classify it as soft power. Many of these treaties are binding, what we would consider hard law. And I think there's no question that the United States has been uneven in its compliance with international law. Like the Nicaragua decision is an example of where the ICJ held that the United States had violated international law in Nicaragua. And the invasion of Iraq was arguably unlawful. But, the International Court of Justice observed in the Nicaragua decision that when countries try to justify their actions in the language of law and by invoking international law and develop sophisticated arguments trying to defend their position, that in effect is reinforcing the normative power of law, right? Even if they are found to be in violation of the law, they are trying to demonstrate that their actions were lawful in the language of law and by reference to the law. What is so troubling for international law scholars today is that we're seeing violations of international law with just complete disregard. and no effort to justify and no reference to international law as being an argument in favor of what is being done. So it's not simply that the violations in the past were done in defense of some ideological position, and that now it's more nakedly self-interested. I think the more problematic aspect is that it's not even being there's no pretense of trying to justify it in legal terms. It's basically simply making naked the idea that we don't care about the law and we're powerful enough that I mean, Stephen Miller basically stated this, right? When he says, like, we are powerful and the only thing that matters is power, right? And we don't have to care about the law. I mean, he didn't say we don't have to care about the law, but that was the implication of what he said, right? And President Trump himself in the New York Times interview said, like, I don't need international law. As someone just noted in the comments. So that's the more problematic aspect. And, but I do think that you're pointing to something that, again, Mark Carey, Prime Minister Carey, mentioned or referred to in his Davos speech, which I don't exactly agree with, but he was basically saying that, in effect, this is just making naked what has already been the case, that international law has always been, in some sense, a pretext. Now, certainly, what's called third world approaches to international law, or TWAIL, it's a legal, theoretical approach to international law that comes out of the global south, would say, yeah, well, this is what we've been saying all along, that really international law has always just been a pretext by which the powerful have, used law as a way of exerting their power over the weak and dressing it up in legal terms. I tend not to agree with that, but there's certainly something to that. But I think, again, if I can refer back to the podcast episode, I just got Monica Hakimi from Colombia says, look, I mean, we're seeing this complete rupture, really. I mean, she's echoing in much more theoretical terms what Mark Carey said at Davos, that this is a rupture, and it's unclear how international law is going to operate in the future. And that's really pretty troubling. But on that note, unfortunately, I do have a call at 1:15 that I have to get on. So thank you all very much for the opportunity to speak with you today. I really enjoyed it and enjoyed the discussion.
Thank you, Craig Martin. It's been most interesting today.
All right, thank you. Bye, everyone.
The video will be posted before the end of the day if internet gods cooperate.
All right, thank you.
On our website.